Okay, it's now 10 o'clock by my watch. The clerk, please call the roll.
Senator Serval, Delegate Bagby, Delegate Mullen, Delegate Samira, Christy Kelly, James Abrenio.
How many people are here?
Commissioner Land.
Here.
Commissioner Oliver, represented by Senior Policy Analyst Allen.
Here.
Commissioner Storin, represented by Chief Deputy Commissioner Berger.
Here.
Vice Chair Price. Chairman Edwards.
Yeah, I'm here.
Mr. Chair, thank you very much.
Do we have a quorum?
We do not, Mr. Chair.
Should we wait for a quorum?
There's no, it's my understanding that we're not planning on taking any votes today, Mr. Chair. So I do not believe that we need to.
Okay. Well, let's just go ahead with what we have. And so I'm going to introduce, first of all, we're going to receive, this is what we're going to do, receive a presentation by Anna Moyer of DLS, and also public comment from those that have signed up. And then we'll have a member discussion. The goal at the end of the meeting is to give directions to council for a structure for reworking the barrier crime provisions so that they can start, DLS can start on draft legislation. That's the goal. We won't be voting though, since this is, I guess, not a formal meeting. So, anybody have any questions about how we get started? Okay, well, let's go ahead and get started. Anna, please give us your draft barrier crimes. Yeah, tell us about the existing barrier crimes of Virginia and what the options are.
Yes, thank you, Mr. Chair. I am going to share my screen real quick. Sorry, my computer is kind of slow right now. Okay, can everybody see my PowerPoint and hear me?
Yep.
Okay, great. Okay, so today I'm going to be doing a drafting presentation. We have had some amazing presentations from agency folks and our stakeholders about barrier crimes provisions in the code and gotten good information about how these laws play out in real life. So at this point, it's important to start thinking about what we want the actual legislation to look like. Things have changed in the code over the years, so old drafts don't necessarily work for what we're trying to accomplish now. So we are just hoping that this meeting will help to give us a sense of direction for the draft. In addition to my PowerPoint, we've provided some other materials that were sent to your emails and are also posted on the study website. There are two lists of barrier crimes. The first one, titled List of Barrier Crimes as set out in 19.2-392.02, lists the crimes in the exact order as they are listed in the code. The second list of barrier crimes lists the crimes listed by felony and misdemeanor classifications. There's also a document that sets out how Senate Bill 1339 interacts with the barrier crimes provisions. This was Senator Serval's record sealing bill that just passed during the 2021 special session 1. The format for this presentation is simple. I'm going to first go over barrier crimes provisions in the code. You all have seen this information before in the agency presentations, so I just tried to set out the information in such a way that we will get through it fairly quickly, and you all can just see all the different code sections and industries affected here as a refresher, because I think that will help inform the discussion today. The second part of the presentation is a non-exhaustive list of drafting options based on member discussion and meetings. I will say this again, but I want to emphasize that the suggestions and options I'm going to run through are not the end-all be-all of what we can do. We can change these options or we can add onto them. I just threw some suggestions together based on what I've been hearing through your comments and meetings. However, that being said, I think that the options I'm going to go to are the ones that make practical sense for drafting in the code. So hopefully we'll be in a good place at the end of this meeting. Throughout the presentation, you'll often hear me refer to code section 19.2-392.02 as the home base section, because that is where the list of barrier crimes is set out, along with requirements related to national criminal background checks by businesses and organizations regarding employees or volunteers providing care to children or the elderly or disabled. The list that we sent you also help you to see more clearly what the barrier crimes are so that you can see what we will potentially be taking off of the list. The list of barrier crimes is organized as follows. In subsection A, in the definition of barrier crime, clause 1 includes crimes against a person, property crimes, crimes involving health and safety, or crimes involving morals and decency, peace and order, and administration of justice. This is by far the longest list within the list of barrier crimes. Clause 2, specific property crimes. Clause 3, specific drug crimes. Clause 4, felony violations of possession of controlled substances. Clause 5, offenses that result in the person's requirement to register with the Sex Offender and Crimes Against Minors Registry. And Clause 6, any other felony not included in the above clauses unless 5 years have elapsed from the date of conviction. Before I go into the specific barrier crime sections, I wanted to show the layout of the code in this format where you can see the different departments and industries to whom these laws apply. Basically, the way it works is we have our home-based section, and then each of the relevant subject matter titles have sections where they reference back to the home-based section about what barrier crimes apply, and they set out their industry-specific rules and procedures. There are many different types of professions involved here, and as we all know, there is no consistency in each of the titles as to how the barrier crime provisions apply. And although we are looking to make these provisions cleaner and perhaps more uniform in the code, there are important drafting reasons to keep the overall structure at least somewhat similar to how it is now, which I'll get into more later. Also, as I'm sure you'll remember, House Bill 1012 and Senate Bill 578 in 2020 transferred the authority to license and regulate child day programs and other early child care agencies from the Department of Social Services to the Department of Education. And additionally, public schools also have barrier crimes requirements. So we have 4 major agencies involved here. Again, since you all have seen this information before, I will try to run through these slides fairly quickly so that it can just serve as a good refresher. The way that I will run through them is by providing the answers to these questions. Who is subject to the barrier crime provisions? What offenses constitute a barrier? And are there any exceptions? So starting with the Department of Health, our applicable code sections here are 32.1-126.01 and 32.1-162.9:1. Who is subject to the barrier crimes provisions? Nursing homes, home care organizations, and hospice employees. What offenses constitute a barrier? Any offense set forth in clause 1 in the home-based section. So they exclude all of the other offenses, including those related to controlled substances. Exception, a provider may hire an applicant convicted of a single misdemeanor not related to abuse or neglect if 5 years have elapsed from the convictions. Felonies are a permanent disqualifier. Department of Behavioral Health and Developmental Services. You can see the relevant code sections listed there. Who is subject to the barrier crimes provisions? State facilities, community services boards, and licensed providers. What offenses constitute a barrier? Any offense set forth in clause 1, 2, or 3 in the home-based section, or any offense set forth in clause 4 in the 5 years prior to the application date for employment, or if the person continues on probation or parole or has not paid their required court costs. Also, children's residential facilities, in addition to the other ones listed there, also include clause 5 in the home-based section, which are the offenses that result in the person's requirement to register with the Sex Offender and Crimes Against Minors Registry. For exceptions, both 5 and 10 years are used as time limits for some crimes. There is a screening process at the discretion of employers for 26 crimes related to substance abuse or mental health when 5 years have elapsed since the conviction. Moving to Department of Social Services, quite a few code sections listed there. Who is subject to the barrier crimes provisions? Foster and adoptive parents, child and adult day programs, and assisted living facilities. For the what and the exceptions, there are variations across sectors, so I will go into those a little bit more specifically now. So for agencies for foster
and I have a question on social services.
Sure.
I thought, let's see, the child and adult daycare programs and assisted living, I thought the child care programs were transferred to the Department of Education. Am I wrong about that? What was transferred to the Department of Education from social services?
Yes, early child care. And I do think though there's still some I do think that they retained, sorry, I'm trying to look ahead. They retained children's.
Mr. Chair, Anna, if you want me to jump in and help here.
Yes.
So what transferred, Mr. Chair, from our agency to Department of Ed was the child care licensing program and the child care development block grant. We still have some child welfare licensing that remained at the department. So we still have some child licensing authority. It's just no longer the child care piece under the child care development block grant.
Okay. Now I'm thoroughly confused, but that's okay. Yeah, thank you for trying to clarify that. It is confusing.
Okay, so for child placing agencies under DSS, this is for foster and adopted parents. The offenses that constitute a barrier: a child placing agency shall not approve a foster or adoptive home with any offense as defined in the home-based section, or if they're the subject of a founded complaint of abuse or neglect as maintained in registries. And also, a child placing agency or independent foster home shall not hire or continue to employ persons who have been convicted of any barrier crime or are the subject of a founded complaint of child abuse or neglect. So child placing agency exceptions, as you can see, there is a long list here of all of the exceptions relating to foster and adopted parents. I won't read each one, but to summarize, there are exceptions for a child placing agency to approve a foster or adopted parent for certain convictions when specific time periods have been met. In the drafting options portion of the presentation, I kept in mind this joint subcommittee's interest in the last meeting and limiting requirements for adoptive and foster parents to just the federal barrier crimes requirements. So I'll bring that back up again later. So for assisted living facilities and adult day centers, what offenses constitute a barrier? Any offense set forth in clause 1 of the definition of barrier crime. Exception: a licensed assisted living facility or adult day center may hire an applicant or continue to employ a person convicted of one misdemeanor barrier crime not involving abuse or neglect if 5 years have elapsed following the conviction. And the last thing under DSS were children's residential facilities, which you'll recall I also mentioned under DBHDS. What offenses constitute a barrier? Any offense set forth in clause 1, 2, 3, or 5 of the definition of barrier crime, or any offense set forth in clause 4 of the definition of barrier crime in the 5 years prior to the application date, or if the person is on probation or parole or has failed to pay required court costs. Exception: a children's residential facility may hire persons convicted of not more than one misdemeanor offense for assault and battery or assault and battery against a family or household member if 10 years have elapsed from the conviction, unless the person committed the offense in the scope of their employment.
So Anna, if it helps clarify some of what I was saying earlier, so those things that you just described, children's residential facilities, and then our child placing agencies, that is what DSS continues to license, not the child care programs, but the child welfare related foster and adoptive programs.
Thank you, Gina. Okay, so moving to Department of Education, who is subject to the barrier crimes provisions here: child day centers, family day homes, family day systems, and public schools. And as you know, we discussed, legislation in 2020 transferred child day programs and other early child care to DOE from DSS. What offenses constitute a barrier? For the child day centers, family day homes, and family day systems, any offense in the home-based section, or if the person is subject of a founded complaint of child abuse or neglect. Exceptions: a child day center may hire persons who have been convicted of only one misdemeanor offense under assault and battery if 10 years have elapsed following the conviction, unless the person committed the offense while employed or if the object of the offense was a minor. There is also a waiver process where the superintendent may grant a waiver to a family day home licensed or registered by the department if any other adult living in the home of the applicant or provider has been convicted of not more than one misdemeanor offense for assault and battery against a person in the home. provided that 5 years have elapsed from the conviction and that the department has conducted a home study that includes an assessment of the safety of children placed in the home and a determination that the offender is now a person of good moral character and reputation. So for public school employees, what offenses constitute a barrier? Any violent felony set forth in the definition of barrier crime, or any offense involving the sexual molestation, physical or sexual abuse, or rape of a child. Exceptions: any school board may employ any individual who has been convicted of a felony or crime of moral turpitude not set forth in the definition of barrier crime that does not involve the sexual molestation, physical or sexual abuse, or the rape of a child, except for that when it's a felony conviction, the person has to have their civil rights restored by the governor. So that was just a quick overview of some of the barrier crimes provisions as they are currently set out in the code. Now I'm going to go through some of the options for how we can start putting together a draft. Again, this is a non-exhaustive list of options, but hopefully I've read the room accurately in our previous meetings about what you all are thinking. The way that I've done this is I first just done some options that could be the full option, if that makes sense. So you all could say, we want you to do a draft of option 1, and we could do that. But then after that, I have a menu slide where I list some pieces and parts that we can pick and choose from to make a final decision and kind of come up with a custom draft proposal. So starting with option 1, eliminate misdemeanor crimes and have waivers of felony offenses. This first option would amend the home base section to eliminate all misdemeanor crimes. The barrier crimes list would then only include felonies. At the end of the last meeting, this seemed like it might be a desirable option, so that's why I listed it first. Applicants would be able to apply for waivers for any or most of the felony crimes included on the barrier crimes list, and each agency would oversee the waiver process for its applicable groups. And we would amend the foster care and adoption sections in Title 63.2 to eliminate any reference to Virginia barrier crimes provisions and have only the federal rules apply. This is under DSS. There are minimum federal barrier crimes requirements that must be in place. So what we would do is just reference the federal law, and that's what would be in place for foster and adoptive care. Members seem really interested in this, doing this last time, so that's why I included it in all of the slides. Option 2 would be a straight waiver process. We would keep the list of barrier crimes as is and allow a waiver process for all or most of the crimes. Again, each agency would oversee the waiver process for its applicable groups. I say all or most of the crimes because you could still eliminate some barrier crimes, such as certain drug crimes, but it just probably wouldn't be as extensive as option 1, where we just straight cut all the misdemeanor crimes. And we would again amend the foster care sections to have only the federal rules apply. Consolidate into one section. So this is an option that members mentioned in the last meeting. And although I think that we can certainly limit the list of crimes and really clean things up, from a drafting standpoint, putting all of this into one section doesn't seem feasible for a few reasons. First, other laws relating to these groups are located in their respective titles. So we may want to keep the barrier crimes provisions in the same location as their other rules and requirements. Also, each group would need the same list of barrier crimes and exceptions, which would maybe work this year, but that could be problematic going forward if agencies want to change their rules down the road and then they're a little different from one another, and then you just have one giant messy section. And then also what we've been discussing is having the waiver and appeal processes to be set out by the different administrative bodies. And so they all might look a little bit different from one another. So it makes sense to put that in their applicable code sections. So the better option that's kind of on par with this would be to amend our current home base section or create a new section that sets out the single general process and the trimmed down list of barrier crimes for each agency. And then we would create a section or article in each title, agency title, setting out all agency specific requirements, exclusions of crimes and waivers, et cetera. And this would be somewhat similar to how things are drafted now, but we would definitely try to organize things better in each title. So it would be a lot cleaner. So this slide basically sums up the options I just went over, plus an additional option. I use the word menu because we can pick and choose from this list to create kind of a custom draft proposal. So the first thing would be to just remove some offenses from the list of barrier crimes. Options that have been discussed include removing all misdemeanor crimes or removing certain categories of crimes. You honestly can do this all kinds of different ways. So that's part of the reason why we provided those 2 lists of barrier crimes in the materials today, so that you can really closely look at what you might really think needs to stay on the barrier crimes list, and maybe look at other crimes and say, we definitely should get that off of there. The second thing, create a general waiver or appeals process that allows an employer to hire persons convicted of certain barrier crimes if certain conditions are met. That can be related to the type of position, type of crime, time since conviction, and other requirements. And we have the specific processes to be set out by the agencies. This kind of waiver process or appeals process can be used in all scenarios, whether the home-based section is amended or not. And I certainly think that this is a good thing to include in whatever we do based on the presentations that we've heard from agencies so far. The third thing I have for the menu is doing a tiered system based on crime severity and have general categories of disqualifying crimes in a waiver process. This is different from simply removing crimes in menu item 1. In this system, you would have your tiered system with general categories of crimes based on severity. So for example, you might have a category where the crimes listed, the most severe crimes listed, are either a permanent bar or a 10-year bar. And then at that 10-year bar, they could apply for the waiver. And then maybe kind of your middle tier of crimes, people could apply for the waiver after 5 years. And then your lowest level of crimes, you might allow individuals to apply for a waiver at any time, or maybe, at some point between 1 to 5 years, with consideration of certain rehabilitation factors. A simpler way to do the tiered system might be to have, if you wanted to have some permanent disqualifying crimes for your most severe crimes. But then for the other felonies, you could make it so that people could apply for the waiver at some point, between 5 to 10 years. And then with rehabilitation factors and then all your misdemeanors, people could apply for that waiver sometime 1 to 5 years with certain rehabilitation factors. Again, you can do this one all kinds of different ways too. Those are just some ideas. And then the fourth thing I have here are that you could, we want to limit background check and barrier crimes requirements for foster care and adoption to mirror federal requirements. And also as a note, we also have to meet minimum federal requirements for child care provider employees. So this is stuff that would be under DOE, I think. And you guys don't have to worry about that, because when Sabrina and I draft this, we'll make sure that everything is in compliance. But I just wanted to make a note of that. As far as pros and cons, of course, DLS has no position, and we can't necessarily speak about the real world implications about how we draft this, as our agency and stakeholder folks can. But from a drafting standpoint, unless you do it by misdemeanors and felonies, the tiered system might take more work of this joint subcommittee trying to determine what should and should not go into each category, whereas whittling down the list of crimes and having this waiver process that each agency would set out might be a simpler way to do it. But we can draft it all kinds of different ways. And you just will have to let us know. I also want to note that we will keep in mind the record sealing bill, Senator Suravel's bill, which we outlined in that handout, like I mentioned earlier. This bill does not go into effect until 2025. And overall, we are not concerned about it negatively impacting how we would do this draft. And we'll just make sure that everything works together. So that concludes my presentation. I'm happy to take any questions, or if anyone has any comments or preferences for the draft at this time, please feel free to put it out there.
Thank you, Anna. Anybody have any questions to Anna? I think everybody.
Mr. Chairman.
Yeah, who's this? I can't see.
Suravel.
Scott, welcome.
Thanks, John. Sorry, I just got out of court.
Hope you won.
I was just setting a trial date. Hey, Anna, I was trying to find a list of the misdemeanor crimes, and I saw the list of the felonies. Is there a list of the misdemeanor crimes we're talking about, if we're talking about getting rid of all of them?
Sure, Mr. Chair, Senator Suravel. I think Sabrina, you can jump in if I'm wrong. I think the misdemeanors are on the classifications list. Are they not?
They are. They are at the end of the classifications list.
Yeah, starting at the bottom
page
of page 6.
Yeah.
On page 6?
Mm-hmm.
Yes.
Okay, well, I did a search for the word misdemeanor in that document, and it doesn't appear. So is there... I understand that certain felonies are count and that there's other sentences here that are probably broad enough to include a misdemeanor, but without listing the misdemeanors, I'm having a hard time figuring out which is a misdemeanor and which is a felony.
Senator, Mr. Chair, Senator Surville, are you looking at the classifications of barrier crimes document?
I'm looking at the list of barrier crimes as set out in 19.2, 392.02.
Okay, there is a second handout, which is classifications of barrier crimes, and it starts with class 1 felony and ends with some unclassified crimes. But in that document, at the bottom of page 6, we've got the misdemeanors.
Okay, thanks. I'll go look at that.
Okay, any other questions? Okay, Anna? Any other questions of Anna? Okay, then now we'll go on to the public comment. There are a number of people who've signed up to comment. I'll just go down the list I have. Michelle Lapidus. Michelle?
Mr. Chair, it looks like she's not in presently. If you, at the chair's preference, I could just read off the names.
You go ahead, Sean. Go ahead.
Yes, Mr. Chair, thank you. First, we'll have Debbie Taylor. I am promoting you to a panelist, and you'll be able to begin right away. Following Debbie, Eileen Longenecker will be next.
Okay, Debbie Taylor of Arlington, Virginia, National Capital Treatment and Recovery, formerly Phoenix House. Is that you, Debbie? Welcome, Debbie. Debbie Taylor.
Okay. Sorry. I'm sorry. I had to click. Can you see me now? Let me see.
I can see you.
There's just a lag. Sorry about that, Senator. Thank you so much. I've had the opportunity to speak on this issue several times over the past 40 years that I've been involved in this field. Prior and during when we've had these, I am really very pleased to see option 1 being discussed, where you would get rid of the misdemeanors and that you would allow individuals to attempt on any other crime for my area of concern, which is substance use treatment. I should have said that in the beginning. I've run treatment programs in the Commonwealth since 1972. And we did it before the barrier crimes were there, and it was all the onus was on us, and we had to do all the checking, but we survived because our population is not a terribly vulnerable population. Our population is a population that does need to be monitored. We, I believe, should be treated more like corrections. And that's not to say that there shouldn't be disqualifying, but like last week, I had to reject an individual who was a woman, 50 years old in recovery, who had 30 years of recovery. She relapsed 5 years ago, and she had an altercation with her adult daughter of 30 years old, and she was charged with assault. And she did not fight it because she went back into treatment, and she's banned. That is unfortunate. That would be someone that I would want to have consideration and an option to be able to make sure she followed a plan. I'm not saying to ignore that or to ignore any type of crime. There does need to be consequences for breaking the law, but I don't think it needs to be ended. So I just really, really applaud the first step that you're looking at. And then again, as I had said before, we need to have more people who can review. The time it takes to get a review done is ridiculous. And I don't know if you would allow each agency to have a review and be able to document their process and send it in to an entity. That might save the state some work, because I think a lot of agencies would be happy to do that and follow whatever the rules were that were laid down. So thank you for hearing from me. I'm here if you have any questions of me.
Okay, thank you, Debbie. Anybody have any questions of Debbie Taylor? All right, thank you very much. Sean, who's next?
Eileen Longenecker, you're welcome to go ahead. And Harold Foley, I'm moving you in now. You will be next.
Eileen.
Yes,
Welcome.
thank you, Mr. Chair. Eileen Longenecker with OES at the Supreme Court. I don't have any comments on behalf of the court system at this time, but thank you.
Okay, thanks for being here. Next, John, who's next?
Mr. Foley, go ahead.
Who's this?
Harold Foley, you can go ahead.
Harold Foley.
I am the organizer for the Civil Rights and Racial Justice Program with Legal Aid. I'm here to support reform because I work with a lot of folks who call me daily who've been, what I would say, returned citizens who don't have the opportunity, who've been like, who had a child, who had a case maybe 20 years ago, and they're looking for jobs and opportunities. So I'm really hoping that we can get this right, that where the folks who are like suffering from not being able to get housing or a job could really get a job in housing. So thank y'all so much, and I appreciate everything.
Thank you very much, Mr. Foley. Next, did anybody have any questions of Harold Foley? All right, next.
Sheba
John?
Williams, I'm promoting you to a panelist. You will be able to speak momentarily, and Richard Walker, you will be next.
So this is Sheba Williams, is that right?
That's right, Mr. Chair.
Okay, Sheba Williams, welcome.
Good morning. Thank you all for having me. As Virginia moves towards a more inclusive state for individuals who have past convictions, I think it's imperative to remove judgment of past offenses in as many places as possible. In my situations, 4 things come to mind. 1, I was immediately fired from a healthcare administrative job after 6 years of never taking a day off, just because I had a felony conviction that had nothing to do with the job. I was not allowed to chaperone my kids because they banned people with all felony convictions. On school field trips, it was okay for me to be in the school as a PTA member and a supporter, but I could not chaperone my kids because of a question about my past conviction that was well over 10 years old. Peer support specialists are imperative to our work. I work in reentry and I do work in pretrial. Peer support specialists go through a vigorous term of learning and helping people and seeking to help their peers, and they are denied the option to get professional licensing, which leads me to number 4. DPOR has a 20-year look-back period, and they will take away a person's opportunity to work and thrive in this Commonwealth because of a crime that has nothing to do with where they're trying to go forward. Those are my 4 things, and I support removing as many barrier crimes as possible. Thank you.
Any questions? Thank you very much. Richard Walker, next.
Mr. Walker.
Good morning, everyone. Thank you for allowing me the opportunity. I tend to agree with Ms. Williams that I'm a product of barrier crimes being overlooked by the Department of Behavioral Health and Disability Services. I have since been a qualified mental health professional for the past 12 years. And that waiver process allowed for me to be grandfathered in to continue to do what I've been doing. I thank Senator Saraville and Senator Edwards for your efforts in helping to remove some of the stigma by instituting possible parole, bringing parole back into the system, as well as expunging records. I was successful with policy for the City of Richmond Department of Education when they were denying individuals that had misdemeanors as a result of misdemeanor of moral turpitude, which I just thought that was a ridiculous legislation or ordinance, because who determines how morally correct that was, but yet they changed their policies to waive that if they were 5 years or older. So that allowed for individuals to be able to apply for positions in a misdemeanor manner. When you go back to the menu that was just proposed, is there any way that they can be taken in whole or in part, or how would that work? That if you can combine either 1, 2, or 3, or 1 and 4, to help ease the pressure of individuals seeking employment, that can help through my reentry program, Bridging the Gap in Virginia. I've been successful by partnering with the City of Richmond's Office of Community Wealth Building, and I do a overcoming barrier workshop on biweekly for them for the past 5 years. And this always comes up. barrier crimes. If there's some way that we can, remove a lot of these barrier crimes, particularly those that are dealing with accommodation or possession charges, that individuals that have, if it needs to be to show some evidence that they've been in recovery, that they've been able to move forward, that after a 5-year, 10-year period, those can be dropped off their record. And it goes back to expungement legislation. I'm grateful for the recent legislation that came in the past general session. However, it needs to be expanded. It needs to be more inclusive of others throughout. Individuals that have been released from incarceration 10, 15, 20, 25 years have already proven themselves to be productive members of society. Those are the ones that need their records sealed. Those are the individuals that a stigma is still being placed upon them, that they're unable to move to a more better quality of living, that they can provide for their families, that they can provide for, their community. This has to happen. And then a lot of the barrier crimes issues will resolve themselves. Virginia touts its horn as having the lowest recidivism rate in the country. All right. It didn't come by these individuals that have been released 15, 20, 25 years of recommitting crimes. It's come because they have become productive members of society. So that needs to go further, in order. I heard someone made a comment that if we bring back parole, the recidivism rate is going to, go high, which I thought was a ridiculous statement. But at the same rate, these individuals have proven themselves to be productive members of society. So let us continue to be able to keep the recidivism rate lower, and let us reinstitute parole to allow individuals to have a more fruitful life than many of us enjoy. I thank you very much for the time.
Okay, thank you. John, who's next?
Jane Lissenden is next, and Leah Mills will follow.
Jane, what's her last name? Jane? What's her last name, Sean?
Jane Lissenden, it looks like she might have dropped off of the Zoom call. Leah Mills, pardon me. It looks like she became an attendee. I'm promoting her to a panelist again. Jane Lissenden, go on ahead whenever you're ready.
Jane Lissenden. Are you there? Jane Lissenden, are you there?
Leah Mills, you're welcome to unmute and go on ahead.
Yeah, Leah Mills of Henrico, DARS. Leah Mills, are you there?
Natima Jones.
Natina Jones of Richmond. Are you there? Natina Jones. Natina Jones, are you there?
I do not believe so, Mr. Chair. And that being the case, that wraps up everyone who has signed up and joined the meeting to give public comment.
Is anybody else from the public would like to say anything? Okay. Thank you all very much. Guess we move on from public comment to discussion between or among members. Any discussion among members? Senator Serval, any comments?
Sure, Mr. Chairman. I'm sorry I missed the last meeting. I think I was hiking a mountain and I missed the last presentation, but in August. I looked at the options that are presented, and first of all, I would say I agree there are some misdemeanors that need to be removed from the list, but carte blanche removing all misdemeanors I think would not pass. And I think there's real problems with it, with removing all of them. There's some misdemeanors on that list, which would give me serious concern about removing. For example, putting things in a child's mouth with lascivious intent, sexual battery, sexual abuse of children, taking advantage of an adult. There's a lot of stuff in there that I think requires somebody to eyeball a situation and look into it before granting any kind of a waiver in a barrier crime. But I agree, there's some things on that list that are stupid, like pointing a laser beam at a police officer, or there's some other pretty minor misdemeanors on there that probably ought to come off. Number two, the waiver system, to me, within each department, seems to me to probably be the best way to proceed, because that gives each agency the discretion to come up with their own factors and circumstances based on their experience and their knowledge of what's in, what's a red flag in their industry and what isn't, and what they want to see from people before they demonstrate, the ability and everything else to do those jobs. So it seems to me that that's probably the best option, number two. But I mean, I'm open to talking about the other 3 and 4 as well. I just don't really fully understand them yet. And I also think it's important to remember the interplay between this and the audit and the ceiling bill we just passed. If somebody is to get, first of all, the ceiling bill only applies to class 5 and 6 felonies and class 1 through 4 misdemeanors. It doesn't apply to class 1 through 4 felonies. And what that statute says is if an offense is sealed, the barrier crime element is automatically lifted with that. However, you can only seal 2 offenses or 2 sets of criminal transactions within your lifetime under the way that's currently written. And so this process would create a nice sort of a supplement or safety valve to that. But we do also have to remember the interplay between the two. That's kind of my initial reaction to listening to this.
Any other comments? My view of the thing is I like option 1, eliminate misdemeanor crimes and waivers of felony offenses. And I don't know how option 2, the waiver process, would work with that, although I think there's a waiver as well. And under option 1, the issue of the one issue may be looking at misdemeanors involving sex offenses. I haven't analyzed them all. Maybe, but I think it's good to start with option 1, and then if the department or individuals think that option 2, that we ought to keep some misdemeanors, we can look at that on a case-by-case basis. There's so many of them. I don't know where you get started, except we could look at when it comes to children, and especially with sex offenses that are still misdemeanors. We could look at on a case-by-case basis, keeping them in some way as barrier crimes, with the option of as well of doing waivers. Anna, how would this work if we keep option 1 and then add certain misdemeanors? How do we do that?
Sure. So, Mr. Chair, that would actually be more similar to option 2, where will be kind of, I guess, a hybrid of the two. So what I'm hearing is I think we definitely want to keep the felonies, at least for now, as they are now. So we would keep those, and then we would, in this initial draft, and this isn't what it has to end up being, but in this initial draft, Sabrina and I do, we can cut all the misdemeanors except for the sex crime related to misdemeanors, start there, and keep those on the barrier crimes list. Create set out the waiver process for the agencies to oversee, and then so we can see where we are at that point. Would that work?
It sounds to me like it would. Senator Sherville, what do you think?
Mr. Chairman, here's my concern about that is that, there are some offenses on here that are not sex offenses, which I think still create concerns. First of all, anything relating to arson. There's a series of offenses here about setting things on fire, and arson is a marker crime for sexual offenses later in life. There's been all kinds of research that shows that when you're younger, if you like lighting things on fire, you often turn into not often, but it's often a marker for people that later become sex offenders. So that's just something that I think why you would ask people, a department, to sort of look into a situation like that. I mean, drug offenses, I think, are a whole category themselves. I don't think there's any drug offenses on here anymore, and misdemeanor. But I saw another one I think about neglecting a child, failing to provide a child with medical attention. I mean, if somebody has actually gone and gotten convicted of failing to provide a child with medical attention, I mean, usually in my experience, first offense, they work it out, goes away. Second offense, maybe you can get it amended to something else. If you actually get convicted of that, it was either a serious felony that got amended to that, or you have a prior record of things like that, which is why the prosecutor wanted you to have that on your record. And we're talking about people that are going to be caring for children, and we're going to say that a criminal conviction for not caring for a child is no longer a barrier. To me, that could be problematic, right? And I think there was another one on here about abuse and neglect of incapacitated adults. I mean, if somebody's actually convicted of abusing and neglecting an incapacitated adult, yeah, we're going to have them, respond potentially caring for people in licensed and secure scenarios. That to me is like, that's why, I think as you go through this list, it would be better if we got feedback from the agencies about perhaps ones that they were more concerned with and ones they didn't care about, and operated off that feedback as opposed to sitting here and making a blanket rule. Because, I like to make decisions based on data and feedback and other people's expertise instead of just saying, misdemeanors are misdemeanors and let's just write them all off except sex offenses. So I think that's the better way to proceed on that.
Yeah, how do we go forward, Anna, with an approach of 1 and 2 and have the agencies look at the misdemeanor part? I mean, the simplest way is to go where the federal rules are. Federal rules apply only, I think, to felonies. Am I right? Federal rules are felonies only?
That's for DSS, for the foster and adoptive care in that context, and also for some early child care, there are the federal requirements for those. And so those are, I think the foster and adoptive care is kind of a not separate conversation, but if that would be like just part of this whole entire bill, that we do is just make it so for foster and adoptive care, they just have to comply with the federal requirements. But that's just like a narrow, part of everything we're doing. And then for everything else, they would cite to the regular barrier crimes list and follow under that. Listening to what Senator Sturvell said, maybe for this first draft, what we can do is, I think what I'm hearing is the tiered system might actually work better, because under the tiered system, you still have a lot of the misdemeanors stay on the list. And then, but it's just that when you can apply for the waiver is sooner than it would be for the felony conviction. So it would keep those crimes on there. It would get in front of somebody who is screening these crimes for potential employees or applicants, I should say. So that would kind of be one way we could do it. And also for the next meeting, maybe what we can do is also give the agency folks some time to actually talk to one another and maybe see if there's a consensus on what misdemeanor crimes they really need to keep and which ones they would like to cut.
I think that's a good idea. Any other comments? Scott, do you have any comments on that?
I think it's a good way to take a first crack at it.
Okay. Is Delegate Bagby here? Delegate Samira?
Mr. Chairman, James Brinio here.
Yes, sir, I'm here.
Bagby's here as well.
Okay. Any comments?
Mr. Chairman, James Brinio here.
James?
Can you hear me? James Brinio? Yeah. Can I be heard right now? I'm not sure.
Go ahead, James.
Yes.
Yeah, we can hear you, James.
Okay, great. So this is a question perhaps demonstrating my, maybe a dumb question, but let's say a crime is not a barrier crime, but it shows up on a record check. What is the ability for an agency or an employer or whoever to say, you know what, I need to look into that a little bit deeper? For instance, let's say we got rid of a barrier crime, but it still was on the record. Do they have, what's their ability to say, well, I'm going to look into that further and then not hire perhaps?
Anna?
Mr. Chairman.
Correct. Oh, sorry. Go ahead.
Mr. Chairman.
Mr. Sherrill.
I think the answer is you can not hire anybody for just about any reason you want, as long as it doesn't violate state or federal law, like on discrimination basis. So, I mean, if you could decide as an employer you're not going to hire people with speeding tickets, there's nothing wrong with that.
Good. All right. Any other questions?
Mr. Chair, I was following the arguments all along, and I think that it makes sense to go through the agencies and see which ones are checking off the list for nothing that has to do with arson or child abuse. I think there's definitely comments there. But I do think that the process of getting through the how shall I say, the paperwork, if you had committed any of those wrongdoings and they are barrier crimes, is quite arduous. I don't know if there's any way to make it easier. I hear it from barbers that had, and this is maybe in the past and it's already been dealt with, but they had marijuana charges on their record and they can't get their license as barbers. That's kind of an example that I hear in my community. And it takes like a year or so, 2 years sometimes to get just through that process. If there's any way to make it quicker, I don't know if it's a resource problem. I don't know if it's a paperwork problem, but it's just something to mention. Thank you. Thank you, Mr. Chair.
Right. Who is that? Who is that last person?
Delegate Samira. Sorry about that.
Mr. Chairman.
Thank you, Delegate. Yeah. Senator Searle.
Thanks. I have a question for Ms. Kelly, if she's available. Christy Kelly, who's on our panel.
Christy
Yes,
Kelly.
I'm here.
Great. Mr. Chairman, my question to her, and one of my concerns is, we can do everything we want here all day long. Take a bunch of things off the barrier crime list and create a waiver process and people can go get a waiver, whatever. But if somebody applies for a job and they disclose that they have a crime, a conviction for which you can get a waiver, and they've in fact got a waiver, they might not even make it to an interview because the employer, the background report, maybe an employer pulls on somebody, shows they have this type of conviction. It's a barrier. Miss Kelly, I know one of her specialties is ensuring that these background checks from employers are actually accurate. And I was wondering if she had any thoughts about things that might need to be included in the legislation to ensure that if somebody is granted a waiver, that somehow appears in the public record so that people are actually able to clear an interview process or actually get an interview once they've obtained a waiver for their next job.
So that's very accurate. Even if there is this law that says it's no longer a barrier crime, it'll still show up on a background check unless there's some provision that says a waiver needs to be reported in the public records. If there is some provision like that, then even if it's reported on a background check, the consumer will at least have some sort of remedy under the Fair Credit Reporting Act and potentially in an amendment to this statute to prevent an employer from using that information in an adverse way to affect their employment. And so it is really important. I think that's a really good point, Senator Surville, to consider how to make the waiver available in public records so that this actually does have the effect that it's intended to. And also a potential remedy. And the remedy could be against consumer reporting agencies or employers for disqualifying someone. That's a potential way to deal with that. Or there could be a curing period so that people are not automatically excluded, because a lot of times employers will have automatic settings on background checks. And even if the information is incomplete or inaccurate, a consumer will be denied because of what's in the background check. If information is not placed in the public record, the background check companies will not have access to that information, and a consumer could be denied without any recourse in that situation.
Thanks. That's what I was looking for.
Okay, if you're looking for make sure the legislation include, Scott, didn't your previous bill deal with something like that?
Yeah, the automatic sealing statute had a provision that required all data brokers to register with the Virginia State Police, and it created a series of remedies if those data brokers continue to circulate records about consumers that are inaccurate about their consumer histories, their criminal backgrounds. This is a little bit different, but there might be some language in there. We might be able to tie it to that statute somehow. I'd have to think about it. Ms. Kelly is probably be good at talking to about that and drafting choices and things as well.
Okay. Yeah, I think it'd be good to make sure there's something in here about that. Are we confusing everybody? Anna, how we doing?
Mr. Chair, you're doing well. This is actually really helpful. We're getting a lot of good stuff here. I guess the only thing that hasn't been discussed, and this doesn't have to be decided on today, but I'm just wondering if any of the members have a position on If there are certain time limits that you would like to have passed before people could apply for these waivers, whether it's a misdemeanor or felony, you don't have to decide that today, but just if you do have an opinion, that would be helpful for putting together this preliminary draft.
I have an opinion. The time limits are pretty long. I don't know if you really need time limits. It depends what the issue is. I mean, I don't know why you need a time. Tell me why you need a time limit, like 5 years, 10 years or something like that. That's a long time.
Mr. Chair, yeah, I think a lot of the time limit stuff is more in the context of really serious felonies. Might be what you would want to consider that for. But I mean, we'll draft this however you all want. I don't have a position one way or the other.
Mr. Chairman.
Yeah, Scott.
One of the issues with time limits is that, what often correlates with recidivism more than anything is age, right? So, older people tend not to commit as much crimes as younger people. And so, a time frame of one thing might work better for one age than another age, which is why I think as we look at this stuff, it ought to be based on sort of data and sort of research instead of just sort of big blanket, rules. So, for anyway, I think you get the idea.
My thought process, a waiver is a waiver. They don't have to grant it. It's been a long time, they'll probably grant it. If it's a short time, they may not. In other words, it's built into the process of waiving the time limits. Have you been convicted of murder? They're not going to grant it. But if you've been out for 30 years and you've never committed one ever, they might look at it. So to me, in other words, the time limits are built into a waiver process because a waiver process is not a guaranteed waiver. That's how I see it. Anybody else have any comments?
Yeah, Mr. Chair, this is Delegate Samara. If I can add, I would say that very similarly, if you committed a crime and you served your time and you're ready to go to work and you want to go right to work, that's the best way to reduce recidivism. I think there's an argument to be made in other direction as well. So let's get these people to work. Let's get them paying taxes and making money and paying for their health care and, doing the regular things that we all do. And that's the best way out of crime.
Okay. Anna, do you have any thoughts?
Mr. Chair, I don't have any further thoughts unless the agency folks wanted to weigh in at this point, but I think that we have some good information for planning for the next meeting at this point.
Okay. Any other comments? Any more discussion among members or anybody else who's here on the call? When are we going to meet next time?
Mr. Chair, we can send out a poll for whenever you want. Just not next week because that's my vacation, please.
Not next week. September, I guess. Okay. Is this going to be an official meeting so we can make decisions or what?
Mr. Chair, I'm not prepared to answer that at this point. We could still possibly do it virtual as long as we're not doing a vote. I guess we can just see where the planning comes down. But it can certainly be in person if you would prefer that it be.
Okay.
Mr. Chair, in the midst of that conversation, do we have maybe a sort of a timeline when we want to have decisions made so that we're prepared going into session?
Mr. Chair, yes. And Delegate Bagby, this joint subcommittee is supposed to complete its work by November 30th. At this point, we have 2 meetings allotted by statute left that we can have. So that's why we really wanted to kind of get started on the draft so we can really be productive in the next 2 meetings. So I guess we probably would have 2 meetings over the course of 3.5 months.
Okay. Let's try.
And Mr. Chair?
Delegate Bagby?
And so I would imagine those 2 meetings, what I'm trying to really figure out is when do we want to really get a really strong draft of what it is we're moving forward with. I know 30th is the deadline, but when do we really want to have something locked in so that other members can really see what we're looking at and weigh in.
Mr. Chair, do you want me to take that or?
Anna, go ahead.
Okay. Well, I guess it just depends on when the last two meetings are. I mean, our goal as staff is we would like to have a completed draft by the second meeting, which I guess would probably occur in October or November. Not that it can't be changed after that, because of course, all that we do in December is draft bills, so we can still work on it. But the goal would be to have a solid piece of legislation that there is some kind of consensus on by our second meeting in October or November.
That sounds good to me.
Thank you, Mr. Chair. My question's answered.
Okay, any further questions? All right, so we'll try to get a meeting in September and then come up with something we can all agree on, if possible, in October. Sound good? That's a game plan, right? Okay, well, thank you all. Any further comments? Thank you all for joining, and everybody had some comments and anything to say from the public. We appreciate you showing up. Cia Price, do you have anything to say? Is she here? Delegate Price?
Yeah, hi, I'm here. No, I don't have anything. This was a great meeting and looking forward to really moving forward.
Yeah, thanks for being here. Appreciate it. All right, with no further business, we'll call the meeting adjourned. Thank you very much. I don't have a gavel. We'll do like this. Thank